Today, we're talking about a crime in Arizona. It's called threatening and or intimidating. So threatening and intimidating. It's actually fairly common. It's pretty easy to have this happen. Somebody can get a little bit riled up. They can start yelling at somebody else, and sometimes in the heat of the moment, we say things that might be construed as intending to cause physical harm. That is a crime in Arizona. We're going to look at the statutes, and then we're going to look at the penalties that are associated with the different levels of conduct that are criminalized under the statute. So where is this law? Well, it's under the Arizona Revised Statutes 13-1202. If you plug that into Google, it should pop up and say threatening and intimidating. The law specifically says that a person can do threatening or intimidation by using words or conduct, so you don't have to actually verbalize it for it to be a threat or to intimidate somebody, but if you also engage in some sort of conduct that does one of the following, that's going to be enough to be charged with threatening or intimidating. So let's take a look at what those are. The first, probably the most obvious, is that if you are threatening through words or conduct to cause physical injury to somebody else or to damage the property of somebody else, that is enough for threatening or intimidating. So this means that you don't actually have to cause that injury or cause the damage to that property, but if you do something, if you're saying certain things, or if you're engaging in certain conduct that is implying that you're going to cause physical injury or you're going to damage the property of somebody else, that's enough under the statute to be considered threatening and intimidating. The other way that you can get it is if you are threatening through words or conduct and that causes a serious public inconvenience. So the statute actually gives us some guidance on what that is, but a serious public inconvenience, whether it's done directly, so you actually are saying certain things or doing certain things to cause that inconvenience, or you're acting recklessly. It's not like you sought out to go do that specifically, but you should have known that your conduct was going to result in the serious public inconvenience. And as I said, the statute gives us some guidance on that. It says that a good example would be the evacuation of a building or a public location or a transportation venue, a subway car or a bus or something like that, where your words or your conduct is causing a serious public inconvenience. People are going to have to be leaving, people are going to have to relocate, it's going to cause the cessation of the transportation. So if that happens, that's also going to be considered a crime under threatening or intimidating. And finally, the most serious way that somebody can be charged with threatening or intimidating is if they are threatening to cause injury or damage property, and they're doing it in the interest of furthering some sort of criminal activity. Things like street gangs, things like what are called a criminal syndicate. So some sort of organization or an enterprise where the conduct is going to be intended to further the interests of whatever that entity is. And it's often, we see this in the movies or something, where in order to get initiated into the syndicate or the street gang, somebody has to go do something on behalf of that organization. They have to go make some threats, or they have to go engage in some sort of conduct in order to further the interest of that entity. And so if that happens, that's going to be threatening or intimidating. Again, doesn't necessarily have to be the actual cause of the injury or the cause of the damage. There are other crimes for those: criminal damage, assault, aggravated assault. Those are all separate crimes, but just the threat, just the conduct or the threat that is implying that there's going to be physical injury or damage is enough. So what are the penalties for this? Well, most of these are considered misdemeanor offenses. So you can see here, numbers 1 and number 2 are class 1 misdemeanors. So in Arizona, we have 3 classifications of misdemeanor offenses. Class 1 is the most serious, that's at the top. Class 3 is the least serious. So these number 1 and 2 are the most serious level misdemeanors that somebody can be charged with. That is, unless this type of conduct is done with the intention of retaliating against somebody for reporting some sort of a crime. So if you're threatening or you're intimidating somebody in the hopes of retaliating against them for reporting a crime, that is going to be actually a class 6 felony. If a person who is alleged to have been doing one of these things, if they can tie that person and consider them to be a gang member, then that's also going to be a class 6. So not necessarily in the furtherance of a criminal gang or a criminal syndicate. But if that person is a gang member and they're doing some threatening or intimidating, the fact that they are a gang member is going to elevate it from a Class 1 misdemeanor up into a Class 6 felony. So that is important. Number 3, if somebody is charged under subsection 3 here, under this statute, it is much more serious. This is actually a Class 3 felony. Arizona, we've got a scale of 6 felonies. 1 is the most serious, 6 is the least serious. So a Class 3 is right there in the middle. It's a very serious offense because of the fact that it involves a criminal syndicate or a criminal gang. The law really wants to penalize that type of conduct, that type of behavior. So if you or somebody that you know has been charged with threatening or intimidating, there are a lot of defenses to these types of crimes. You can imagine sometimes the words or the conduct can be misconstrued. They're said in the heat of the moment. They're not actually intended to cause physical injury. They're not as clear as otherwise you might think. In other words, sometimes people just say things. They're fighting words. People are getting in heated arguments, but it doesn't necessarily rise to the level of threatening or intimidating. That type of conduct needs to be a little bit more clear. So as I said, if you've been charged with threatening or intimidating, you or somebody you love watching this video, give us a call. We offer free case evaluations. We do criminal defense law. We represent people all over the state of Arizona. We have a great team here to make sure that you are not convicted of this type of an offense, whether it's going to be on your record as a misdemeanor or a felony. We want to make sure that it's just not there, period. So give us a call. Free case evaluations. We'll get a time scheduled. You can come into the office, sit down with our team, make sure you have an understanding of how this works, and more importantly, that you have a plan. Give us a call. Look forward to speaking with you soon. Thanks for watching.